Thank you. For judgment. Special weekly list for judgment, item number 1, STRAB 109 of 2008.
Petition stands allowed. Issues are decided in favor of the SEC and against the department. The impugned order is set aside. Order of the SSD is restored. There is no order as to cost.
Item number 2, WPC 19449 of 2009.
The writ petition stands dismissed. The order of stay stands vacated.
Item number 3, WPC 12026 of 2010.
Writ petition is allowed. Impugned order is set aside vis-a-vis the petitioner. The order of status quo is vacated.
Item number 4, WPC 28125 of 2011.
Writ petitions stand dismissed. Consequently, the status quo order is vacated.
Item number 5, WPC 14286 of 2016 and batch of matters.
By virtue of this decision of the court, the General Administration Vigilance Department of the Government of Orissa cannot, notwithstanding the impugned notification dated 11 August 2016, refuse to divulge information pertaining to corruption and human rights violations, which information is expressly not protected from disclosure by virtue of the first proviso to Section 24(4) of the RTI Act. Also, information that does not touch upon any of the sensitive and confidential activities undertaken by the Vigilance Department cannot be withheld. For all the aforementioned reasons, this court issues a direct declaratory writ to the effect that the impugned notification dated 11th August 2016, issued by the Information and Public Relations Department, Government of Orissa, under Section 24(4) of the RTI Act, will not permit the government to deny information pertaining to the Vigilance Department involving allegations of corruption and human rights violations, and other information that does not touch upon any of the sensitive and confidential activities undertaken by the Vigilance Department. A further clarificatory notification to the above effect be issued by the Government of Odisha within 4 weeks. The writ petition are disposed of in the above terms, but in the circumstances with no orders as to costs. Grateful. None appears. Dismissal not possible.
Special weekly list, old matter item number 7.
This is state.
Yes, madam. Lord, it's a forward matter, madam. So the question of law is at page 5, madam. Whether in the facts and circumstances of the case, the Learned Sales Tax Tribunal Odisha was justified in holding that the blank audio cassettes and recorded and branded audio cassettes marketed by the opposite party under the trade name JE are same commodity, and as to whether any process of manufacture is involved herein. Here, my lord, what the dealer was doing, he was purchasing blank tapes and pre-records audio therein, and thereafter he sells it. So he was claiming input the tax paid while purchasing the tapes, that he was claiming as credit while selling. The department said, since the commodities are different, you are purchasing blank tapes, pre-record audio, and sell it as a pre-recorded cassette. Hence, there are two different materials. So the tax paid while purchasing tape cannot be claimed set off while selling the audio cassettes, since they are two different commodities. And the Honorable Supreme Court, my lord, in this case, has held that these two are different commodities, my lord.
What's the tax effect, and has the opposite side been served?
Lord, tax effect is minimal, my lord, 22,000.
Then we leave it for some other case, because nobody appearing also. Considering that the tax effect is minimal, the court is not inclined to entertain the present revision petition. However, the question of law urged is left open for consideration in an appropriate case. All right.
Old matter item number 8.
Item number 8, Willers.
Yes.
In this case, similar matters was there before your lordship on 18/5/2022. Sirs, I have given compilation of judgments, Willers, and your lordship have framed 2 questions, Willers, and directed all 10, almost nearly 10 matters. Your lordship directed all the matter to come on 22nd June. Day after tomorrow.
All
So
right.
yes.
Day after. All
Day
right.
after tomorrow. In the supplementary list, all are coming, Willers.
All right. List day after tomorrow. All right.
Obliged.
Special weekly old matter item number 9.
Here, my lord, tax effect is 7,990.
All right. Review of the tax effect. Right.
Item number 10.
May I please, Your Lordship? The question of law which falls for Your Lordship consideration is at
It's already been framed.
Yes, ma'am.
28th August 2000.
Yes, my lord. Whether on the facts and circumstances of the case, the Honorable Sales Tax Tribunal is justified to disallow the branch transfer in as much as the relevant documents of branch transfer, including declaration form F issued by the branch office, has been furnished by the appellant. What has happened, Your Lordship? I have. It is not in dispute that I have effected branch transfer to my head office at Calcutta. I'm a paper manufacturing unit. I manufacture paper and thereafter I send the goods in consignment. All the supporting documents, including the declaration F forms, have been submitted before the assessing officer. That is not in dispute. What the assessing officer says, that, or the forum below says, that the branch which has received the goods has sold the goods on the same day or the other day on the receipt of the goods. My humble submission is that basing on the suspicion and surmises that this is an interstate sales, it has been my branch transfer has been disallowed and it has been treated as interstate sale and tax has been imposed, my lords. The relevant finding of the learned tribunal is at page 25, my lords. Para 5.
Yes.
I must place
It
it.
was next contended.
Yes, ma'am. It was next contended by the learned advocate for the dealer that the forum below were not justified in rejecting the claim of the dealer in respect of branch transfer, particularly when the seller has filed the supporting F forms in respect of such claim. The learned additional SR, on the other hand, argued in support of the impugned assessment made by the forum below. Perusal of the assessment reveals that the order of assessment In the order of assessment, the learned assessing officer has observed that in almost all these cases, the claim of branch transfer, which have been disallowed, the quantity, quality, and specification of papers are almost the same as the order placed by the customers, and accordingly, he has held that it is nothing but post arrangement of records for the verbal or telephonic requisition of the customer. To add to this, the learned ACST in his order observed that the order were received within a short period and disposed of immediately within a day or two. From the copies of various papers received on 2/4/88 by the branch have been sold to the customer on 4/4/98. That the quantity of dispatch and quantity of sale are almost the same. Similarly, in the case of goods received on 3/4/88.
So it's a whole pattern, sir. It's not a one-off thing, it's a pattern.
Yes, madam.
Everything is being sold within 2 days and identical dispatch quantity. What is sold is exact tallies with what has been dispatched. It's all purely factual, sir.
But my lords,
Not
my-
really.
and
But I was
my-
wondering how this could be a question of law at all. It's a pure question of fact.
My lords, when I have, my lords, kindly see the sections, what the section says. What is
No.
the burden which,
No, see, what is a giveaway is this quantities. The dispatch quantity
my
is
lord,
tallies perfectly with the sold quantity.
Yeah.
Normally, when these are consignment or branch transfers, the quantities will not match perfectly, and not transaction after transaction. Occasional one-off one can understand, but not every transaction can't be like that.
my lord,
And this is a possible view to take. I don't think we can interfere.
but my lords, if there is the forums below have held that I have, this is an interstate sales.
That's right.
But
it is.
for
It is.
interstate sales, there should be
So it's
some
not just the
adverse-
proximity of the sale. It's also the quantities are all matching.
there is something more which is required to be termed as an interstate sale. In my humble submission, there should be a contract that or
Yeah, all that is,
Translation
good on paper.
completely on presumption, my lords.
Right. No, this is not a presumption. This is a actual analysis of factual situation. All right. You say by the order dated 28th August 2000, this court had directed the following two questions to be referred to it by the tribunal for its decision. We produce the two questions. Paragraph. The short issue involved in the present petition is whether the alleged branch transfers by the petitioner SSC to its Calcutta office were in fact disguised interstate sales. Paragraph. The tribunal has in the impugned order in para 5 noted as under reproduced para 5 paragraph. The counsel petitioner strenuously argued that the conclusion that these were interstate sales was based on surmises and conjectures, and that the documents produced by the petitioner to prove to the contrary were ignored by the authorities below. Paragraph. Apart from the fact that the sales by the Calcutta office took place within a day of receipt of the transfer of consignment, the important fact to note was that these were a pattern of sales effected in similar fashion, where within a day or two of the receipt of the consignment, the sale was effected, and of an identical quantity and description of the goods. Full stop. This could not be merely termed to be a coincidence. Full stop. It is this that has persuaded the tribunal not to accept the contention of the SSC. Paragraph. Having considered the submissions of learned counsel of the parties, the court is not inclined to interfere with the reasoned order of the tribunal, which upholds the orders of the corresponding orders of the assessing officer and the ACST. Full stop. The view taken is a plausible one and arises purely from the factual situation in the case. Full stop. Consequently, the questions are answered in favor of the department and against the SSC. The revision petition is dismissed.
Special list item number 11.
Defects not removed.
Tax effect is also 56,000.
All right. Apart from the fact that defects have not been removed for over 10 years, even the tax effect is not substantial to persuade the court to interfere. Leaving the questions open, the revision petition is dismissed.
Special list item 12.
Expressed, my lord. File not traceable, my lord. So
All right. Counsel, if the petitioner states the file is not traceable, the petition is dismissed, giving liberty to the petitioner to revive it as and when the file is traced.
Special list item 13.
My lord, tax effect is 13,000.
Low tax.
Special list item 14.
May I please?
Yes.
Here, my lord, I have challenges two ground. One is, my lord, violation of principle of ritual justice on the ground that I have, my lord, date of fixed, my lord, the hearing before the tribunal was 3/7, 3rd September 2007. my lord. In paragraph page 6, ground number B,
What's the tax effect, sir?
4 lakh something, my lord, as government society, my lord,
Okay.
state government society. Only the merit of the case is not dishonour declaration form produced before the authority on the ground. If a lordship see the order of the sales tax officer that non-filing of the eligibility certificate that has been decided, lordship see straightway page 7, internal page 7. That is the only issue. And second one is, in spite of 1B, I have filed 1E. That has been disallowed behind back of the petition, lord. If not, it could have been said that is incorrect declaration. I could have replaced that. That has not been placed before the at the time of assessment. Could not be stated before the authority because by mistake it has been filed E1 form, which is not exactly correct. It is also a mistake in the part of the petition, lord. Apart from that, lordship, see the page 7. That is clarify everything. Merit of the case, lord. On the demand, no documentary evidence are produced for verification to
Page
assert
7 of?
page 7, running page 7, internal page 7 of the assessment order. Running page 17,
17.
17.
Yes.
On demand, no documentary evidence produced for verification to ascertain the eligibility for purchasing dealer to purchase the goods and production of declaration in form ID. The RC of the dealer discloses that it is an oil mill since 26/9/86. It may be a fact that the unit could have undertaken expansion, modernization, diversification under IPR 89. The declaration for indicate that the unit has been set up on 1/12/89 and started commercial production 24/8/93. It is a fact is not clear and convincing in absence of illegal certificate. Moreover, the copy of certificate of concerned DIC issued in favor of unit could not be furnished for very sure the tax exemption sale.
So if you have not produced the eligibility certificate.
Yes, this eligibility enclosed, your lordship. See, running page 44. That has not been produced because he has not asked for, my lord.
No, you
Once I have filed the declaration form, my lord, the declaration I have declared this unit is exempted. It is a subsequent requirement document to produce if it is not doubted the declaration form.
No. First, you have to file the eligibility certificate.
No, the condition is I have to file the declaration form only to claim the exemption. If it is doubted, then he is asked for to produce the eligibility certificate, lord. And your lordship, so many
Even
cases,
the declaration was in the wrong form.
no, that two set of ground. One is declaration of E1 I have produced, which is not correct. Another is disallowance 1D. There is two dealers, my lord. One is rice mill, another is oil mill. Two part has been disallowed. One part is declaration form. I have correct declaration form produced, but non-sum in the eligibility certificate that has been disallowed. Second one is I have filed E1 in spite of 1D. That is true ground. And if I could have given opportunity to a tribunal, I could have produced all this same. Though I have filed a telegram, I have enclosed.
No, let's see what the tribunal does.
Tribunal state, your lordship, see running page 31. running plus 30 say none has appeared from this dealer side in course of present proceeding. He has
Then-
not said any
So,
date. to it.
so what do? You have an opportunity, you don't appear.
But I have filed it. I have sent a telegram. I have enclosed the receipt. Will not see. I have enclosed the receipt. State government will not. Why should it not?
Or let it go back to the tribunal.
Yes, that is what.
Allowed may kindly see page 31 for a moment.
We have heard the state only.
Paragraph 6,
That's what.
the tribunal notes down the four subclauses. The declaration.
No. But first paragraph itself, we have heard the state only. We have no
Yes,
occasion
my
to
lord.
hear the dealer.
My lord, may see the bottom paragraph. In fact, in the first appellate order was an ex parte order because the dealer didn't appear. Second appellate order, yes, also he didn't appear, ex parte order. So
Said a
now
telegram lordship. See,
in any
page
case,
33 telegram receipt is there. No. Telegram receipt is there.
so
Page
two forums
33.
was available, he didn't appear, didn't file the declaration forms.
No, I
Now,
have
even
declared
before this honorable court also, he's not giving any list of those declaration forms, or he's not asserting that those declaration forms are there.
That's
Well,
not
that's
correct.
not the government also.
That is not correct, Mr. Pandit. That is not correct. I have filed a declaration. He's doubted that I have not filed the eligible certificate. First one. Second one is I have filed E1 certificate. It's not correct.
Do you have all these documents or you don't?
I have document. I have enclosed the eligible certificate. Kindly see. I have the eligible certificate in laws running plus 44 issued by the DIC. Only give opportunity to solve the purpose. Not.
All right. They admit following question of law as framed for consideration. Foresee. Is the SSC liable to be heard again by the Orissa Sales Tax Tribunal on account of its inability to appear when the impugn order was passed for bona fide reasons? Question mark. Paragraph. The present revision petition arises from an order dated 3rd October 2007, passed by the Orissa State Tax Tribunal in essay number 1691 of 2001-02, whereby the appeal at the behest of the present petitioner was heard in the absence of its absence by the tribunal, thereby affirming the order dated 30th October 2001 of the Assistant Commissioner of Sales Tax, Cuttack 1 Range, Cuttack, bracket ACST, which in turn confirmed the assessment order dated 27th of February 1999, passed by the Sales Tax Officer, bracket STO, Cuttack, under Section 12, bracket 4 of the Orissa Sales Tax Act for the year 1995-96, raising a demand of rupees 346,921. Paragraph. The impugn order of the tribunal notes in para 6, open quotation. We have heard the state only, full stop. We have no occasion to hear the dealer, as it having chosen not to contest the case, has been set ex parte, unquote. As it transpires, even before the ACST, the dealer's appeal was dismissed on account of its non-appearance. Stop. Mr. Satpathy Leonard Counsel, the SSC, refers to the telegram sent to the tribunal by the dealer. Telegram receipt. Receipt of the telegram sent by the dealer seeking for time to appear and make submissions. Full stop. The tax effect being over rupees 4 lakhs and the dealer having furnished an explanation for non-appearance before the tribunal, which appears to be a plausible one. This court is of the view that the dealer should be given one more opportunity to be heard by the tribunal in its appeal. Stop. For the aforementioned reasons, the impugn order dated 3rd October 2007 of the tribunal is hereby set aside, and essay number 1691 of 2001-02 is restored to the file of the tribunal for being listed there for direction on 11 July 2022. 18 July, say 18 July 2022. It is made clear that on that date, the dealer through its authorized representative must remain present for the appeal to be taken up afresh on merits, uninfluenced by the earlier decision, which has been set aside by this court in the present order. The question is therefore answered in favor of the SSC against the revenue in the above terms. Revision question is disposed of.
My lord may only indicate that my lord has not expressed any opinion.
Yeah, obviously. See, it's clarified that no view has been expressed by this court on merits.
My learned senior is there.
There.
Yes, minutes,
Sorry.
item 16.
Yes.
Your lordship may kindly straightway will turn to the questions raised at page 33, my lord. There are 3 questions, my lords. Page 33. Whether in the facts and circumstances of the case, a refinery unit set up by the petitioner by way of expansion after 1/12/89 eligible for sales tax incentive under the provision of Central Sales Tax Act in respect of interstate sales read with entry 30 FFF2 of the sales tax bill schedule under the Orissa Sales Tax Act 2. Whether in the facts and circumstances of the case, furnishing declaration form F in respect of claim of stock transfer under section 6 of the CST Act is mandatory, and whether it is proper on the part of the Learned Tribunal not to make any deliberation on the said issue which is pleaded before it. Third is whether in the facts of the case, levy of surcharge purportedly under section 5A of the OST Act is lawful and valid in respect of transaction under the CST Act.
Before my learned senior starts, my learned senior has just now handed over a long list of judgments.
No, that is not long list. No, it's a matter of paper.
The 10 judgments A has just handed over. So let me go through the
answered. No, these are all answered. Sorry. Question number A, Millards, has already been answered by this honorable court. I have given only a 1-page order that to my friend Millards to know that, because it's a matter of record. But question number B has also been answered. C has not been discussed and deliberated, and no order is passed by the tribunal. Even if under section 24(1), this honorable court, Millards, has power when a question raised, the question is not erroneously decided or the tribunal failed to decide. Under these 2 circumstances, your lordship will assume power to answer the question. I am just taking your lordship's attention. What is question number 1, Millards? My lordship kindly turn to Millards, page 84. Page 84. Initially, I was manufacturing Millards, the solvent extraction plant, crude oil, and after expansion, I was manufacturing refined oil. That is mentioned in page 84. There are 5 lines from the bottom. I am not listing everything. In the year 1992, the apparent unit undertook expansion of solvent extraction plant by adding a refinery unit thereto for manufacturing refined oil, wax, acid oil, soap stock from crude oil. The said expanded refinery unit started commercial production on 16/2/94 and was certified by the General Manager DIC Sambalpur to be eligible to sales tax incentive under clause 7, part 1 of IPR 89, reduce 26 FF 30 FFF2 list of rate of tax and for a period of 7 years till 15 to 2001. Now the case of the department is page 86, paragraph 4. Next, paragraph 4. Authorities of the learned fora below have held that the appellant is not entitled to any sales tax incentive exemption under IPR 89 after 1398. As the refinery unit set up by the appellant under expansion, modernization, or diversification is not eligible for any sales tax exemption under 30 FF2 of list A. They further held that after withdrawal of the benefit of value notification of the appropriate government, extension of such benefit incentive is not at all available to the appellant after 1/8/99, with effect from which the data was withdrawn by the notification. My claim was up to 2001. Now government has withdrawn in the meantime by notification saying that after 1/8/99 you are no more eligible. even if certification was there by the DICGM for till 2001 minutes. So therefore, your lordship said you will get benefit up to 1899. And the period which your lordship is concerned is 99-2000. That means I will only get exemption up to 1899, not for the entire period. That is what I am submitting. I am not saying I will be. Now, your lordship kindly turn to Miller's Annexure 7, page 73, page 74 element, assessment order. What he has disallowed, your lordship will see. Miller's page 74, internal page 2, I am placing 7-8 lines from the top. The refinery unit of the dealer, page 74, 7-8 lines from the top. The refinery unit of the dealer has come up after the solvent extraction unit commenced production and the commercial production refinery unit was ensued with effect from 16 to 94. The DIC of Sambalpur issued certificate by letter number 5012 dated 2798 stating the refinery unit of the dealer as the EMD unit of the solvent extraction plant. Basing such certification, the dealer claimed tax concessional benefit on purchase and sale of EMD portion and the refinery in accordance with the entry 30 FF2 of tax procedure of West Act. Plus, I am stopping here. Now, the lordship kindly see the top 2 lines. During the page 70, that page. During the instant year, as per return filed by the dealer, the sales in course of interstate transaction stands at 2,02,31,368, and that of consignment sale stands at 1,04,06,261. The consignment sale with the stock transfer. They have nomenclature as consignment sale. So my stock branch transfer is 1,04 lakhs and sale is 2.20 crores. So lordship knows. The question which I have raised before lordship, I was reading just a little while before Miller's claim of branch transfer under section 6 of the Central Sales Tax Act. And your lordship knows that after 2002, Miller's C form is form F is mandatory. The only mode of discharging Miller's my claim of stock transfer is mandatory to give form F. After 2002 Parliament Amendment Miller's. This period belongs to Miller's 99-2000. And for this period, I have annexed 3 judgments of this honorable court. 2 judgments of this honorable court, 1 Kerala High Court judgment.
Mr. Sahu, he will need time to study the matter. No? He's just got the...
Minor. Absolutely. I don't have any blood. I cannot. Sorry. Absolutely.
We'll admit it and frame the questions.
Correct.
Correct. Admit the following questions are framed for consideration. Take from page 13. Are you pressing the surcharge point also?
Surcharge Miller's, I am because what I am saying earlier, that issue was left open. Miller's, I think your lordship only can decide. We cannot keep this issue open for a indefinite period without resolving. Your lordship can, because the provision itself, your lordship you can resolve this.
In fact, your lordship would see the second and third question, stock transfer and surcharge, that issue was never raised either before the appellate authority or first appellate or before.
No, that I will show to my lords.
That was in fact, the issue was never before the first or second.
That is why I have given to my friend a copy of the compendium which inputs copy of the ground show appeal. And ground number 4 is explicitly clear that the question is raised, not addressed by tribunal. My friend may see this. My lord, giving time, you can see this. And good. Surcharge, your lordship said, in many occasions, we have left this issue open. But I think your lordship may kindly decide.
No, but if you have not urged it in the tribunal, why should we entertain?
No, tribunal. With the tribunal, I have filed a note, Millards. Because
clearly saying that the grounds of appeal now have been handed over. He's saying that grounds of appeal it has been raised. So I'll go through, Malad. But in the order, from the order it appears, Malad.
Yeah, you say these 3 questions then, 1, 2, and 3. You see, complete. Mr. Sahul and senior counsel for the petition has added over a set of documents and citations with their copy to Mr. Padhi, learned counsel for the department. Mr. Padhi seeks some time to respond at his request list on 2nd August.
May I please, my lord? The issue involved in this case is the first point tax paid good purchased from unregistered dealer, my lord. And recently, your lordship already decided in favor of the assessee. And before that, I may be permitted to read the second and third para assessment order at page 8, my lord. May I-
Yes.
The second parameter, assessment order, page 8, verified the purchase registered. It is revealed that all the purchases are supported with vouchers and the same are reflected in the purchase register. During the year under assessment, the dealer has effected purchase size wood and logs from unregistered dealer to the tune of rupees such and furnished the first point tax paid list. During the course of examination of account, it is seen that the learned advocate furnished the money received such and such. In the third para, as regards sale, it is seen that the dealer has effected total sale to the tune of rupees and all the sale proceeds are claimed as tax paid sales. Verified in detail of sale keeping in view of the purchase. As the purchases are effected from unregistered dealers, the claim of first point tax paid purchases and paid sale tax cannot be accepted. This is the only ground, my lord. And recently, your lordship, and there are several decisions, but now the recent judgment of your lordship, I am submitting the para 26, 25, 27, and 28 are relevant. Para 26, that page 11, my lord, starting the issue number 2.
Yes.
There are two components of sale in question here. One is regarding the tax payable on sale of cold drinks and the other on the sale of IMFL. As regard the sale of cold drinks, it is not in dispute that the petitioner is not the first seller in respect of cold drinks. It has produced the invoices to show from whom it has purchased the soft drinks. The tribunal appears to have rejected the same invoice only because the seller was not a registered dealer. The issue is same, my lord. And in my case also, the tribunal held and on basis of a judgment of this honorable court reported in 69 STC. In that case, there is involved the form Roman 34, my lord. That decision is not applicable to my case, my lord, which one the relied by the tribunal, and only on that basis they rejected my claim. And that decision is not relevant to my case since there is the issue involved the form number 34. And the 34 is relating to the concessional tax. That is by the purchaser dealer produced before the selling dealer. And to get the underground, that they will sell that within the state of Orissa. That is the only issue they are involved in form 34, my lord. So tribunal only on that basis rejected my submission, my lord.
Yes, Mr. Bhatt.
My lord, I have not been given a copy.
Here again, no, it has not yet been admitted also. What's the tax effect here?
Only tax effect, my lord, 62,000, my lord. That is,
I don't
but
believe-
the matter is covered with the tribunal committed error, my lord. Apply a decision which is not applicable to my case, my lord. My written submission also enclosed, my lord, filed before the tribunal. That is annexure 3, my lord, at page 13, which are not totally considered, my lord.
Here, my lord would consider what he is claiming that I have paid tax at the first point at the time of purchase, so that I need to get set off. My lord, what the department has said that since you have purchased it from an unregistered dealer, now an unregistered dealer while selling, he cannot ask for payment of tax. Department cannot chase him. So there is as on date when he is claiming set off, the payment of tax to an unregistered dealer, my lord, that's what has been dealt with.
My lord, here the main dealer is the Orissa Forest Development Corporation.
So maybe, my lord, anybody, if he is an
And he
unregistered dealer,
collected
he
the
cannot,
tax.
if he is an unregistered dealer, my lord, while selling, he cannot charge tax. That's the law, my lord.
Kindly have a glance the decision of this honorable court passed in STRV number 20, para 26, 20.
See, I'm claiming exemption. If it's an unregistered dealer, how do you get out of that?
My lord, the similar case, my lord, STRV 20, I have produced that
Yes,
here he purchased from unregistered dealer.
No, but that turned on something else. We come to page para 26.
My lord,
Para 26 of that judgment.
Yes, my lord, that para 26 already, there is two part, my lord. The IMFL first point tax came in 1995-96.
There, the petitioner was the first seller, my lord.
Correct.
No, my lord, in that case, petitioner is the hoteler.
As regards the sale of the third line, as regards the sale of cold drinks, it is not in dispute.
It is not sale, my lord, it is
It
on
is not in the
purchase.
first dealer, my lord. So it's different.
I'm here, I have purchased from unregistered dealer who purchased from OFDC. That is the point, my lord, here.
The second,
I'm not the first purchaser. And the unregistered dealer is not the first seller, my lord. Here, the OFDC is the first seller. Kindly have a glance to the, my lord, tribunal order. The only point, the tribunal only relied on that decision 69 STC. Only on that ground is disallowed, not any other ground, my lord. And that case is related to form 34, my lord.
no. That's on first point tax paid goods. My lord, may I read that judgment? That's at page 18. Page 18, second paragraph. Further, in para 5 of the judgment, the Honorable High Court has explained the meaning of the word series, which reproduced below. In section 8, therefore, the meaning of series has great importance. The word has not been defined under the Act, where two transactions are so clearly linked that one is a continuation of the other. It is said to be a series. Normally, on completion of a sale, the transaction comes to an end. However, under the scheme of the Act, tax is to be levied at one point of sale only. A dealer who sells the goods in course of business is liable to pay tax on such sale. If he is not registered under the Act, he has no right to collect the tax from the purchase. Only where he is registered, he is given the option to collect the tax from the purchaser as provided under section 9 capital B. If the selling dealer chooses not to collect the tax, there is no compulsion on him. He may prefer to take the burden on himself. The law enunciated by the unquote, Miller, the law enunciated by the Honorable High Court makes it abundantly clear that series starts with a registered dealer and continues so long as the goods in question are being handled by successive registered dealers. Ultimately, series ends with the last registered dealer.
That is applicable to form 34, my lord, where it is submitted by the purchasing dealer as undertake to resell it, not to use otherwise. That is the and the unregistered dealer cannot sell to a registered dealer and collect the form 34, my lord, to make him concessional rate of a tax collect. That is the issue involved in that case, my lord. How can that be applied to my case, my lord?
But you also purchased it from an unregistered dealer.
But that is the first point tax paid goods, and it is the Orissa Forest Development Corporation is the seller is here, and the unregistered dealer collected from them. There is no question applicable to me, my lord, that I again paid the same. Since the decision is squarely under Supreme Court, and that in that decision based on the Supreme Court decision, my lord. Madras Court, High Court decision affirmed by the Supreme Court, and relying on that decision, my lord, and there are several decisions in favor of that if a first point tax paid goods and even if purchased from unregistered dealer, he can be eligible to, there is no liability of paying again that on that point.
The statutory provision, it is page 17. It has been quoted at page 17, section 8. That in a series of sale, if it is paid at the first point, it will not be paid.
That series of sale in that is for 37, form 34, my lord. And here is the first point sale tax.
No, in this case, which you are relying on, this Akbari Continental.
Yes, my lord, para C 26, 27 and 28.
No, 26, the tribunal for years of 1993, 94 to 96, 97 accepted that cold first point.
Yes, my lord.
That is why
no, I'm basing on the judgment of the para 27, my lord, can have a grant. That is the case law relied by this court.
Sales and tax was really paid.
Once it is first point tax, there is no liability to by the second dealer or
unless the tax has actually been paid, sir.
Kindly keep it to tomorrow. I will produce some judgment on that basis. My lord, there is the large number of decisions in favor of the assessee, my lord. And
you're not inclined, sir. You say the present revision petition arises from an order dated November 2007, passed by the Orissa Sales Tax Tribunal in essay number 2154 of 2003-04. whereby the appeal filed by the petitioner SSC, petitioner dealer, against the order dated 22nd August 2003 of the Assistant Commissioner of Sales Tax, bracket ACST, was dismissed. Stop. Consequently, the assessment order passed by the Sales Tax Officer, bracket STU, under Section 12, bracket 4 of the Orissa Sales Tax Act 1947 for the year 1999-2000, raising a demand of Rs 62,397 on the petitioner, was upheld. Paragraph. The petitioner carries on business of sizing of wood and logs on retail basis. For the year in question, one of the issues that arose was whether the goods purchased by the petitioner from unregistered dealers could be held as first point tax paid goods. Stop. In the impugned order, the tribunal has, after noticing Section 8 of the OST Act and the decision of this court, in Messrs. Single Trading and Company, the state of Orissa. What is the citation of that?
I've produced that one copy, my lord, 69 STC, my lord.
The other one. (1989) 1988, 69 STC 329 bracket Orissa. Come to the conclusion, following conclusion. Take from the bottom of page 18, open quotation, the law enunciated by the Honorable High Court makes it clear in the whole of the next paragraph. Mr. Panda, learned counsel for the petitioner, sought to place reliance on a recent decision dated 7 September 2021, passed by this court in ST REV 20 of 2007, bracket Akbari Continental Private Limited, state of Orissa, to urge that, notwithstanding that the purchases were made from the unregistered dealer, the benefit cannot be denied to the petitioner. Benefit of setting off of the tax paid cannot be denied to the petitioner. He also placed reliance on the decision of Madras High Court in Govindan and Company, State of Tamil Nadu, 1975, 35 STC 50, which had in turn been affirmed by the Supreme Court in State of Tamil Nadu versus Raman and Company, 1974, 33 STC 1. Paragraph. The court is unable to agree with the above submissions, Mr. Panda. We'll start with it seen that as far as the Madras High Court judgment in Govindan and Company packet Supra is concerned, it was held therein that to claim benefit of tax on the ground that the sales effected with SSCs were second sales, they need not show that their sellers had in fact paid tax at the first point. Full stop. It was open question enough for them to show that the earlier sales were taxable sales and tax was really payable by their sellers. Unquote. In the present case, with the sellers being unregistered dealers, the occasion to show that the earlier sales were taxable sales did not arise. Full stop. So the same effect is the decision in Single Trading Companies, State of Orissa, Supra, So in other words, while the petitioner dealer may have purchased the goods from unregistered sellers, it had still to be shown that the tax had actually been paid at an earlier point in time. In the present case, that burden has not been discharged by the petitioner. And therefore, the tribunal was justified in negating its plea. Paragraph. For the aforementioned reasons, the court is not satisfied that any substantial question of law arises for consideration from the impugn order of the tribunal. Petition is dismissed.
Obliged.
Right.
Special list item number 18.
None appears dismissed now.
Special list item number 19.
Item 19, Your Lordship, on behalf of Mr. Lal, item 19 and 20, no instructions.
No instructions. All right.
Special list item 21.
None appears dismissed now.
So, my lord, may kindly see there, my lord, may issue fresh notice because the advocate concerned is, my lord, is now been elevated.
No, but it's a 2008 matter. So many things have not been done.
Yes, yes.
You say receipt of showing of the defects pointed out have not been cured for over 12 years now. This was an opposite.
Special list item 22.
My lord, no instruction, my lord.
No instructions. Dismissed from opposite.
Special list item 23.
My lords, I don't want to mention, my lords, there's some defects, my lords. The first time it has been listed, my lords. Assessment and appellate has not been furnished, my lords. I've given my lords. May kindly accept.
Not like this, sir. You have to cure defects.
I'll defer that.
No, it's a 2008 matter. You can't suddenly wake up in 2022 and say
Pardon,
now
pardon,
I'm curing
pardon, my
defects.
lord. Pardon, my lord.
No.
Pardon, my lord.
No question of pardoning 14 years, sir. Defects have not been cured for over 14 years now. The court is not inclined to therefore grant any further time to the petition of this purpose. The petition is dismissed for non-purpose. Yes.
Special list item 24.
Item 24, Your Lordship, no instructions.
No instructions.
Special list item 25.
Item 25, Your Lordship, there's no instruction.
No instructions. Dismissed.
Special list item number 26.
None appears dismissed. No.
Special list item 27.
May I please, my lords? The question which arises, my lord, for your lordship's kind consideration, my lord, is the enhancement which has been paid for a suppression amounting to rupees 5,58,469, my lords. There's a few facts, my lord, is the petitioner commenced his business, my lord, with effect from 1st of February 2004, my lords. And there was a visit by the Intelligence Department on 14/5/2004. And they allegedly detected certain suppression. Your lordship would get it at running page 18 of the assessment order, my lords, totaling to 5,58,469, my lords. So for this, my lord, without considering the fact that this particular business was in commencement just for 4 months, they considered that the enhancement has to be made for the entire year of 4/5, my lords, without restricting it to the quarter ending June. And, my lords, they enhanced the turnover estimated sale to 27,68,197. The lordship would get it at page 19, unnumbered paragraph 2, my lords. Running page 19 of the assessment order, my lords. According to the suppression of sales estimated to 27,68,197, my lords. When the alleged detection of suppression was amounting to 5,58,469, my lords. I went up in first appeal, my lords. The first appellate authority, my lords, on a detailed analysis, restricted it to 3 times, my lords. Your lordship would get the reasoning at page 23 of the first appellate order, my lords. Running page 23, my lords, which is a part of the first appellate order, my lords.
Yes.
Lordship got it, my lords?
Yeah.
The last paragraph, beginning with I.
Yeah.
I have examined the impugned order of assessment, gone through the grounds of appeal, heard the learned counsel for the appellant, as well as verified the books of accounts of the appellant and the related documents, etc. carefully. On verification of the books of accounts by the learned assessing officer with the returns filed by for the material period, no discrepancy was noticed. Your Lordship and market notes. But the learned assessing officer took the adverse view inference on the basis of an adverse report received from the STO investigation unit BBSR, establishing purchase suppression of 11,704 and sales suppression worth rupees 5,46,765. As it reveals from the record, the appellant, a woman entrepreneur, started the business just 4 months from the date of visit of the STO investigation on 14/5/04, and she had not prepared the sale register for the year 45. So the sales effected against the challans as well as handwritten slips were not found to have been recorded in the sale register. Without making reference to the sale register, the stock discrepancy of the commercial goods exhibited for sale by the appellant was also worked out with the report of purchase suppression of 11,704 and sale suppression worth 122,288.
The tax liability came down to 2,13,000.
My lords, I went up for a further modification to the tribunal, my lords.
Yes.
The tribunal, my lord, now restores the assessment order, rejects my appeal, restores the assessment order, says that the state's first appellate authority was not within its jurisdiction or did not.
Oh, in your appeal, they say the first appellate authority was not justified.
My lords, and they allow the cross appeal and they allow the cross objection.
Oh, the cross exception.
The cross objection was there. My lords. But your lordship would see the reasonings, my lord. They say that if your lordship would kindly return to running page 28, my lord.
Yes.
There was a cross objection.
Yeah.
They say it is an occasional suppression. May I just place it? It is pertinent.
Yes.
It is pertinent to know that on the date of inspection of the visiting officers found that the dealer has not maintained the sale register for the year 45, taking into the efforts of suppression and the fact that the business was newly 4 months old on the date of inspection and completion of assessment to the best of judgment, the learned STO estimated the suppression of sales indulged by the dealer for the year 45 to 27,98,197, which is as good as 5 times of the occasional suppression of 558,469. Accordingly, the gross turnover of the dealer was determined at rupees so and so. During the deducting from therefrom rupees 3,11,270, and he's deducted. Then your lordship sees paragraph 3, my lords. Challenging the legality and correctness of the assessment order, the dealer.
Correct, just tell me, 14 years this has not even been admitted, and the tax has also not been paid.
No, I think it must have been paid. Otherwise, it must have been paid. My only humble contention, my lord, is if your lordship would restrict it to 3 times what has been done by the first appellate authority with cogent reasons, my lords. It's not, and your lordship would appreciate.
What do you say, Mr. Padi? She was a first-time entrepreneur. She conducted business only for 4 months for that year.
That's a fact, but he was caught with
So-
all these suppressions.
Yeah,
5
yeah,
lakh
but
rupees.
thrice the suppressed
Real
amount is fair enough. All right. You say, admit the following question of law is framed for consideration. Was the tribunal justified in setting aside the order of the ACST in a cross appeal by the department and restoring the order of the assessing officer? Question mark. The present revision petition arises from an order dated 29 January 2008. Is it 20th January or 29?
29 minutes.
2008 passed by the Orissa Sales Tax Tribunal, Cuttack. The cross execution is not numbered separately, is it?
No, no.
In essay number
But-
998/2006-07, which in turn arose out of an order dated 8 June 2006 passed by the Assistant Commissioner of Sales Tax, bracket ACST,
But they refer to the cross objection at page 31.
reducing the assessment framed under section 12 bracket 4 of the Orissa Sales Tax Act for the year 2004-05 by the Sales Tax Officer, bracket STO, bracket Bhubaneswar 2 Circle, from rupees 361,463 to 13255. Paragraph. The background facts are that the dealer deals in marbles, glazed tiles, and other types of tiles on wholesale and retail basis. So the petitioner, who's the proprietor of the concern, was registered under the OCT Act effective from 3rd February 2004. For the year 2004-05, she returned the gross turnover of rupees 31,53,705 and taxable turnover of rupees 23,58,106.76. Sales tax and surcharge amounting to rupees 319,185 was also paid. Paragraph. A fraud case report was submitted by the STO investigation unit on 22nd June 2004 regarding sales and purchase suppressions. Stop. Cash of rupees 41,220 was found during the visit of the inspecting officers on 14/5/2004, for which no cash or credit memo had been issued. Full stop. On verification of physical stock, discrepancy was found in terms of in respect of 10 items of goods. The inspecting team also found purchase suppression of 11,704 and sales suppression of 122,288. Stop. The certain documents were also picked up by the inspecting team. Full stop. In the detailed report submitted by the team, sales suppression amounting to rupees 558,469 was detected. Full stop. Paragraph. Taking into account the fact that the business was only 4 months old on the date of inspection, the STO proceeded to complete the assessment on best judgment basis and estimated the suppression of sales as 27,98,197, nearly 5 times the actually deducted suppression. Paragraph. In an appeal by the SSC to the ACST, the
Page 24.
right. By an order dated 8 June 2006, the enhancement of tax was limited to thrice the actual suppression, and the tax payable was accordingly calculated on that basis. Stop. while the SSC went further in appeal before the tribunal, seeking further relief, department filed a cross appeal against the order of the ACST. Full stop. The tribunal has an impugned order held that the ACST was not justified in reducing the enhancement to 3 times the actual suppression and restored the order of the STO. Paragraph. This court has heard learned counsel for the parties. Full stop. The tribunal appears to have overlooked the fact that the SSC had only conducted 4 months of business in the year in question. And that was one factor that weighed with the ACST in reducing the enhancement to thrice the actual amount of suppression. Full stop. In the considered view of the court, since this was a new venture and it is possible that the SSC was not fully aware of all the legal requirements, the view taken by the ACST enhancing the taxable turnover to 3 times the actual suppression did not call for interference, as it could not be said to be arbitrary or unreasonable. Consequently, this court restores the order of the ACST to file and sets aside the impugned order of the tribunal. The question framed is accordingly answered in favor of the SSC and against the department. The revision is disposed of in the above terms.
May I just humbly pray, my lord, any amount paid in excess of what has been directed by the ACST, my lord, may be refunded.
Obviously, you will go. They don't have to mention that. We don't even know if that payment has been made.
Much appreciated.
Special list item 28.
Here, my lord, the question of law, it is page 5.
Defect not removed. For over 13 years now, the defects pointed out by the registry have not been removed. Court is not inclined to grant any further indulgence on its behalf. The petition is according to list. Same for 29 also.
29, it's a delay of condemnation was 2123 days delay.
In 29?
29.
29, there's a delay of 2123 days in filing the revision petition, which has not been satisfactorily explained. Accordingly, the revision petition is dismissed.
Specifically, item 30.
Okay, my lord, 1964 days delay.
1964 days delay, not satisfactorily explained.
Specifically, item 31.
May I please, sir? May I please, sir? There is some defects.
Yeah, not removed for over 12 years, sir. Defects have not been removed for over 12 years.
First time there is some substantial question of law.
That will be left open. You say the questions of law are left open for decision in an appropriate case. All right.
Specifically, item 32.
My lord, delay is 1157 days delay.
1157 days delay, not explained properly. 33.
1555 days delay, my lord.
1555 days delay, not properly explained.
Item 34.
Dismissed.
Before it's 800 days, my lord.
Again, 800 days, not properly explained. Dismissed.
Item 35.
35, it's 1200.
Why do you people file also? 1200 means 4 years later you are filing.
Item 36.
That is 5 years.
5 years. All right. Not bad.
Item number 37.
37, it's 5 years.
5 years delay, not satisfactory explained. Dismissed.
Item number 38.
38, my lord, here 2 months, 70 days delay, my lord, and substantial question of law is involved, my lord.
What's the tax effect?
Tax effect is also, my lord, use. It's 1 crore 80 lakhs.
38.
38, my lord. Yes.
All right. The delay in filing the revision petition is condoned. What's the question? Let's see. What is the matter?
Page 5, my lord. whether in the facts and circumstances of the case the dealer under invoiced the price of the goods or not, particularly when the price at which the IMFL is being sold after the date of takeover is less than 50% of price at which it was being sold before the date of takeover. Two, whether in the facts and circumstances of the case when
I'm sure it's a covered matter. Let's go to the tribunal's order. We'll know that.
the tribunal starts from page 35.
Yes.
Page 38.
Yeah, the forums below.
The forums below were of the view that is because Maharashtra Distilleries Limited, which is a unit of Saw Wallace and Company Limited, took over the dealer appellant with effect from 28/6/99. The price was reduced with effect from 12/5/99 to avoid the first point tax. The stand of the dealer appellant is that the price list was revised on 12/5/99, that is prior to the takeover of the dealer by Maharashtra Distilleries Limited with effect from 28/6/99. In the new price list, the trade discount of different brands which were allowed earlier were discontinued. And if the trade discount allowed earlier is to be taken into consideration, then there is less difference between the earlier price and the price fixed with effect from 12/5/99. The further stand of the learned counsel for the dealer appellant is that by selling of IMFL to Saw Wallace and Company Limited at a slightly lower rate, the dealer appellant could save expenses on marketing of its products, including advertisement expenses. And by adopting these tactics, the dealer had earned more profit than the previous year. The revenue has not been able to contradict this contention of the dealer, though in the assessment order, no reference has been made to section 12(9) of the OST Act, but it seems the enhancement of GTO has been GTO's gross turnover has been made by applying the said provision. The order of the learned SCST, which confirms the assessment order of the learned STO, corroborates the application of section 12(9). According to section 12(9) of the OST Act, in order to establish under invoicing, the revenue is to prove the dealer had sold the goods to the favored buyers at an unreasonably low price compared to the prevailing market price of such goods. But in the instant case, the forums below have not cited a single illustration where the price in which the dealer sold his goods is less than the prevailing market price of such goods. But on the sole basis of charge of under invoicing is the comparison.
You have not discharged your burden, please. You can't simply say it's under invoicing.
But that's an admitted fact. Just before the takeover, he has reduced the price.
But it's already before the takeover. So
before the takeover, yes, Malad.
What he did before the takeover was actually unreasonable. That you have to show.
But
by showing what was the market price then.
But in comparison to his sale for the previous year.
But that mere comparison is not enough unless you show compared to the market price. This is far.
Yes, Malad, that was not there. That's the fact. But in comparison to his sale price for the previous years, it was unreasonably low.
All right. The following question of law is sought to be urged by the revenue in the present revision petition, which arises from an order dated 20th May 2008, passed by the Orissa Sales Tax Tribunal, Cuttack, in essays 213 and 331 of 2001-02, which in turn arose out of an order dated 30th March 2001, passed by the Assistant Commissioner of Sales Tax, Ganjam Range, Berhampur, in Sales Tax Appeal A 364/2000-01. Just take the question from question 1, page 6. No, not 1 minute. Question 1, page 5, bottom of page 5. Paragraph. The basis for the revenue raising the above issue was the alleged drop in the sale price by more than 50% after the takeover of the dealer by Maharashtra Distillery Limited, which is a unit of Saw Wallace and Company Limited. As pointed out by the tribunal, the takeover took place on 28 June 1999, whereas the price was reduced with effect from 12 May 1999 to avoid first point tax. Full stop. In other words, the reduction was much prior to the actual takeover. Full stop. As further pointed out by the tribunal, no material is placed by the revenue before it to actually substantiate its plea that there has been under-invoicing compared to the prices prior to 12/5/1999. Stop. This is not able to be disputed by counsel for the petitioner. Paragraph. In the absence of materials to show there was in fact under-invoicing amount, no presumption could be drawn in that regard. Full stop. Paragraph. Consequently, the court finds that the tribunal has not committed any substantial error calling for any interference by this court. No substantial question of law arises. The petition is dismissed.
Special legal list item 39.
Delay is what?
39, my lord, it's 5 years.
5 years delay, not satisfactory, dismissed. 40.
Special legal list
40,
40.
my lord, it's 85 days, 40 and 41. Both are, my lord, similar. Here, substantial amount is also involved and substantial question of law, my lord, also.
Let's see.
But may kindly turn to page 7, my lord. Whether in the facts and circumstances of the case, the learned tribunal as well as the first appellate authority justified in holding that there was no transfer of right to use the dresser within the meaning of section 2Z 4 of the OST Act. Whether in the facts and circumstances of the case, the learned tribunal is justified in deciding the second appeal on merit without remitting the matter to the learned STO for adjudication.
Yes. Let's see that.
May I pray, Lordship, that I'll address this on the next.
Sorry.
I'll go through in detail, my lord.
Or at the request of counsel the petitioner. List 41, 42 next week.
40, 41.
40, 41.
Yeah.
Listed next week. Monday, next Monday.
Special legal item 42.
42, my lord, delay of 6 years.
6 years delay not satisfactory. Dismissed.
Special legal list item 43.
Lordship, item 43. The order of 2011 is yet to be complied with, Lordship. Lordship, kindly see the operative part, order of the part, let's appear set. Page number 18, Lordship. Running page 18, last paragraph, Lordship. And also I'm reading the last sentence also, Lordship. Therefore, the writ petition must succeed and direction must be issued to the opposite partner too for reconciliation of the matter by giving wide publicity, inviting persons interested to participate and give them the offer of market value in respect of the property. We should direct if the offers to be received would fall short of the market value, the proceedings may be deferred till the property fetches market value. Until the property fetches market value, the same need not be sold. For the opposite reason, the writ petition is allowed. Issue and opposite to is directed to comply with the direction of issued in this order by taking necessary steps as expeditiously as possible. Let's see page 24. Let's kindly see the last part, 2011, page 24. They have replied. Could request Tahsildar Brahmangiri and Collector Puri to evict the occupants from the suit scheduled land so that the property can be put to auction. It is further respectfully submitted that Tahsildar Brahmangiri is the interim trustee of the institution in question. Time and again, this deponent requested him to evict the occupants. Furthermore, this deponent has no machinery to evict the occupants from the suit land. In both the same, the allegations and deponent committed contempt of the court are blatant lies and they are denied. Lordship, till date, they have not complied. They are still in position and it is yet to be put to auction. Lordship, the property of the Lord Alarnath, Lordship.
Yes, who's appearing?
43. Contempt. The endowment commissioner, ex-endowment commissioner is the contemnor.
No. Collector Puri and Tahsildar Brahmagiri have other persons who are to... Then the property can be put to auction.
43, yes. I will take instruction. File is not available. I will take instruction.
All right.
Let it be.
Mr. D.K. Mantil, an additional government advocate. But you've made only the commissioner party.
The direction was made,
That is why I am saying.
direction was made to Milord Commissioner Lordship.
No, the commissioners filed an affidavit saying that the collector and they are not cooperating.
But there are specific
So that
direction to
is why
commission.
there
Now, commissioner is saying Milord collector and Tahsil not complying the order.
Correct.
If Lordship says then implement party Lordship because
No, how can implement them in a contempt?
but Lordship in writ petition direction was to Commissioner Lordship. That's why I made party to the commissioner.
So if the commissioner can't himself evict, he needs the help of the collector and Tahsildar, and the direction says that without evicting them, you should not put the property to auction. How can you blame the commissioner? You file a writ petition for that. You see,
Only the commissioner is the opposite party in the.
Correct.
That is why.
That was the order of the court also.
Anyway, but
it
that
is
is why
seen
we
that
are not.
it is seen from the show cause affidavit of the Commissioner of Endowments that he was not able to put the property in question to auction sale since the occupants of the property were unable to be evicted. Stop. He had made requests to the Tahsildar and Brahmagiri and Collector Puri after the order passed by this court on March 2011 in writ petition civil 9962 of 2011 Stop. To the said authorities. But without the occupants being evicted, he was unable to proceed with the auction. Paragraph. It is seen from the order of this court that the specific direction was issued to the commissioner not to proceed with the auction of the property without evicting the occupants. Stop. To that extent, it cannot be therefore said that the commissioner disobeyed the order of this court. Stop. Paragraph. If indeed the problem is about the occupants continuing in the property in question, it will be open to the petitioner to file a separate proceeding for directions to the Tahsildar, Brahmagiri and Collector Puri to take effective steps pursuant to the order dated 4th March 2011 of this court. With the aforementioned liberty, the contempt petition is disposed of.
Let's.
Special request item 44.
But I am appearing for occupant number 1 and 2, and my learned friend is for.
I am appearing for
compliant.
I am appearing for opinion number 3, 4, and 5. Already complied.
Or the opposite parties confirm to the court that the orders in question have already been complied with. The petition is disposed of.
Special list item 45.
Wait, please, Your Lordship. My Lord, item 45, Your Lordship may permit the petitioners to file a fresh representation before opposite part number 3, that is the collector Bhadrak. Your Lordship has protected me by way of an interim protection. The fact of the case is that, Your Lordship, we are all residents of an area, Kesavnagar colony. Now that colony is situated adjacent to Bhadrak College. Now we have been using a road since long, and the college authorities by registered agreement has agreed that it will be provided as a road to the colony, because otherwise the road is cut off. Even an ambulance cannot reach the colony. Even a fire brigade team cannot reach the colony. And mishaps have happened where by blocking the road, people have died. Even the rescue operations could not be done. So that is the road we have to be used to approach the main town. And if it is cut off, we cannot survive. On that basis, we have approached this honorable court that let it not be prevented from being used as a road. Your Lordship has been pleased to consider the matter, and by order dated 4/1/2013 has permitted that status quo over the road be maintained. Now, in the meantime, Your Lordship, this registered document that the college has executed and many other documents we have got, and there is one peace committee formed. Now, peace committee, they are trying to settle the matter so that the persons will not be deprived to get an approaching road.
And you withdraw this, sir. You withdraw
My
this
prayer is that,
representation.
your lordship, since the matter is there, your lordship may permit me to file a fresh representation before the
All right.
collector Bhadrak.
All right,
And let the
counsel, the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation to the collector Bhadrak in accordance with law.
Your lordship may permit that if a representation is filed within particular time, let the
All right,
collector.
if the representation is filed not later than 1st August 2022, it shall be examined by the collector in an appropriate reason order.
Would your lordship would your lordship would be kind enough to record a statement that the boundary wall has already been constructed? It's a property. All right, as your lordship.
Yeah. And a reason order should be passed thereon not later than 10th October 2022 after hearing all the affected parties.
Yes, your lordship may kindly permit that the interim or status quo may continue till that.
That will not be- that will
Let
create
us not-
problem.
Yeah, that will complicate things.
That will
Because
create
your
problem.
lordship,
Yeah.
in that case, your lordship, there is one contempt also pending. During the pendency, they tried to construct.
It's a
but
college
they-
It's all right.
property.
That will be disposed of, sir, whatever the contempt petition.
Yes, that will create problem.
Yeah.
So
It's a
let your
college
lordship, the
property.
interim
The
status quo
petition
may
is
continue
disposed
till
of as
that date.
withdrawn with liberty in the aforementioned terms.
Yes.
Liberty is prayed for in the aforementioned terms.
Yes.
The
Then
interim order, your
Contempt
lordship, may
petition,
continue
you
till
say
that date only
disposed
before
of
the
in terms of
collector.
the order passed today. What is the contempt petition number?
My lord, the contempt petition is 43 by 2013.
Take it on board and say in view of the order passed today in writ petition civil 115/2013, this contempt petition is disposed of.
My lord, your lordship may kindly permit me that we may pray for an interim protection before the collector. That your lordship may permit.
2013 construction is already over. It's a college.
No, your
property,
lordship,
it's a
construction
public
is not
property.
over. This is a disputed
that
question
suit
of
has
law.
been dismissed.
It will be open to the petitioner to seek appropriate interim
Yes, your
relief
lordship.
to the collector. All right.
Obliged.
Special legal list item 47.
And 46, I have to file counter.
Sir,
What is this
47
anyway? We're taking it up next week only.
Okay, 47, my lord.
47.
Lord, item 47, Lord, I am otherwise ready in the matter, but the principal matter is, Lord, that is WPC number 1728 of 2013.
Oh,
That's
well,
a matter, my lord, it was already mentioned and date is fixed to 24th of 6, 2022.
all right. List on 24/6 along with 1728 of 2004.
Yes, so both the matters can be
Same
disposed of.
petitioner, same petitioner.
Same petition,
Right.
same petitioner, two sets of properties, principal matter is
1728.
172.
All right.
Special legal list item 48.
24/6.
48, in fact, we have filed the counter, your lordship, and the paragraph 7, internal page 4.
But who is for the petitioner?
Nahin.
We just pass it over once. 48.
Special legal item 49.
And my lord, I am appearing for the OP number 1, Pollution Control Board, my lord.
All right.
We have already taken action against the crosser unit, which is
Anyway,
the subject matter
we
of
say
case.
none appears for the petitioner. This was not possible.
Special legal list item 50.
Item 50, that PIL was filed as no for non-permission of the guideline for payment of the unemployment allowance to the disabled person who has registered their name for 2 years. My lord, in the meantime, yesterday I got information that the person who filed the petition as the secretary of that organization, he has died.
So you file a fresh petition, madam.
Yes.
If the cause of action survives, it will be open to the petitioners to file a fresh petition. The petition is disposed of. Right.
Special legal list item 51.
None appears dismissed in non-prosecution.
Special legal item 52.
And I am appearing for OP number 3, Pollution Control Board.
I am for OP number 5.
All right. None appears dismissed in non-prosecution.
I am for OP 6 minutes.
All right.
Special legal list item 53.
No instruction, your lordship.
No instructions dismissed in non-prosecution.
Special legal list item 54.
54, I am appearing for the petitioner. Your lordship, may kindly say order number 3 dated 9/10/2013.
Chess Federation.
Yes, and there, my lords have directed for stay of annexure 9. Now, that was valid for a period of 2 years.
That's
And
over
in the
now.
meantime, that The Lordship may only observe that this annexure 9 shall not be treated adversely against the petitioner in future. But that will suffice.
By an order dated 9/10/2013, the order at annexure 9 was stayed by this court. It is pointed out that the order was valid only for a period of 2 years. And therefore, the interim order has worked itself out. It is clarified that the said order would not be treated adverse to the petitioner in future proceedings. The petition is disposed of. Okay.
Special legal list item 55.
None appears dismissed from prosecution.
Special legal list passed door matter item number 48.
None appears dismissed from prosecution.
Weekly list. Weekly list fresh admission item number 1.
Your Lordship may kindly permit me to withdraw with liberty to file a fresh application.
All right. Counsel the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition. Dismissal is withdrawn with liberty is paid.
Obliged, Your Lordship.
Weekly list fresh admission item number 2.
Your Lordship.
Item 2.
Apology, Lordship. Your Lordship.
Yes.
Your Lordship, there is an application challenging the action of opposite party number 3 and 4 for pressing for physical and offline application, despite PSB, which is opposite party number 1, prescribing for online application. Your Lordship, may I kindly draw your attention to page number 127, Your Lordship.
Yes.
Your Lordship, it speaks, as you may be aware that Public Enterprises Selection Board invites application for filling of vacancies for board level posts in various CPSCs in physical form. There are instances where the application received by either incomplete or were received after the last date of receipt of the application. Such applications are rejected at the time of shortlisting, thereby affecting the career prospects of the applicants. To obviate such situation and to make the process user-friendly and transparent, PSB will be introducing online application procedure shortly. The online application system will be uniform for all its stakeholders and will also facilitate the nodal agency and the cadre controlling authority in speedy verification of the application is timely forwarding to PSB. Your Lordship, in the meantime, online mode has already been in operation. Your Lordship, however, opposite party number 3 and 4 have been insisting on physical application. Your Lordship, now may kindly draw your attention to page number 146, Your Lordship.
What is your problem, sir?
Your Lordship, they are not forwarding, they are insisting on physical application because of which
What is your problem in giving a physical application? What is your problem?
Your Lordship, they are being kept at pending at the CSC level, which is the nodal agency, and they are not being forwarded within the time in a time-bound manner, Your Lordship. That is the problem here.
What is CSC?
Lordship, the nodal agency, Your Lordship. Your Lordship, for example, may I kindly draw your attention to page number 146, Your Lordship.
Yes.
Lordship, these are the applications which have been pending at the nodal agency level, which have not been forwarded to PSB by the prescribed date, Your Lordship.
No. Where is your application? When did you file it? What is this? We're not able to understand that. How are you concerned?
Your Lordship, I'm an applicant, Your Lordship.
When did you file your application? When did you give it to the nodal agency? When did they receive it? Where are those details?
Lordship, may kindly grant a pass-over. I'll just churn out the details.
No. That has to be set out in the petition itself.
Your Lordship, it's there in the petition, Your Lordship. Just. Your Lordship, actually, page 146 is deficient, Your Lordship. Your Lordship, in that case, kindly grant me the liberty to withdraw. I'll file a fresh application.
All right.
Giving all the details properly.
We'll withdraw the present petition, liberty to file a better petition in accordance with law. All right.
Weekly list item number 3. Weekly list fresh admission item number 3.
We'll pass over once.
Weekly list fresh admission item number 4.
May I please lordship, my lord? Item number 4, my lord. The opposite party number 4 to 9 illegally encroaching the government land, that is Gochoro and Gramyo Jungle, my lord. In the meantime, the petitioner along with the villagers filed a representation before the collector Baleswar.
Page 39. Page 39.
All right. Petitioner's representation dated 7th February 2022 will be examined by the collector Baleshwar. And after giving the petitioners as well as opposite parties.
Better it can be examined by the concerned Tahsildar.
Tahsildar, all right. Basta Tahsil. Basta Tahsil.
Tahsildar Basta.
Basta. Tahsildar Basta. And after giving a hearing to the petitioners, notice to the petitioners and opposite parties 4 to 9, and after giving them a hearing, pass reasoned order not later than 10th October 2022.
Obliged, my lord.
The court clarifies it is not expressed any view in the matter. All right.
Weekly list item number 5.
My lordship, that can be passed over.
All right. 5 is passed over.
Weekly list item number 6.
May I please lordship, the petitioner are the villager of Chitramunda of district of Bholangir. My lord, they are being agreed because annexed to my lord representation they are filed because the NRGS work which has been executed by that Gramya Rojagar Sebak, he illegally has not properly done, my lord. And the excavation of pond of the Panchayat pond has not properly excavated. And after excavation, your lordship, the inner is the mud and the sand which will come out, inner side of the pond again fed.
Annexed to at page 13, the video Murari Bahal.
Video Murari, I object. They are
He is to examine the representation of the petition.
Collector also, collector.
No, the video.
There's one 2A.
No, page 13, annexed to 2, that is the Odia.
I know, but it's a long ago, made a representation made in 2021.
My lord. 21,
representation.
No, he approached. They are approaching video and collector also.
All right. The petitioner's representation 29/12/2021 shall be examined by the BDO.
Muri Bahal.
And after giving the petitioners an opportunity of being heard, the reasoned order shall be passed thereon not later than 17th October 2022. Court clarifies it is not expressed in the matter. All right. The petition is posted.
My lord, collector also authority, collector, higher authority, 31st day is a collector. 31st, he has received. Collector.
I say, video will do.
Video is, he will playing video. Say, again over. How? Collector,
all right, will be examined by the collector. All right. Shall be examined by the all right. Collector of which place?
Collector
Balangir. All right, Balangir. All right.
Weekly list for orders item number 7.
One week time to remove the defect, my lord.
It's already 2021 matter, sir.
My lord, that is relating to this matter is relating to villagers, my lord. That's why this matter listed before the PIL bench.
Let the representation be examined by the concerned authority and then
all right. The petitioner's representations.
Page 42.
And 45 series.
Series, my
will be examined by
Tahsildar Hindol.
Tahsildar Hindol. And after notice to the petitioner, reasoned order should be passed. After hearing it. Not later than 19 September 2022. The court clarifies it is not expressed anywhere in the matter. All right.
Weekly list item number 8.
In this matter, Section 3B of the Grantinate Order 2009 is under challenge, which is contrary to
2004 grantinate order. That's lordship.
There all these grantinades are coming up on some date. no?
So all the batch matters.
In past writ petition, I have not been sought with a copy, but in
That-
fact,
that
in
I'll
the, in
do
the
it.
second writ petition, there is no challenge to granting order 2009. It has been challenged to the 2004 order, which is no more in force
Yeah.
after 2009.
That amendment, we have filed amendment was allowed. Thereafter, we have filed amendment petition. We have to serve only copy to the petition.
All right, copies of the petitions be served on
To-
learned counsel for the opposite party state during the course of the day. When are those matters coming up?
Let's say
28th. 28th.
Of June?
Yes.
Oh, list on 28th. All right.
let's see. I have served already. I'm serving here in the.
Serve another copy, sir. All right.
Weekly list item number 9.
Item 9, my lord, 1 week time may be granted to, for removal of the defects.
All right. List after removal of defects.
Weekly list item number 10.
On behalf of arraignment, I am submitting to my lord. This is a PIL matter, my lord.
Defects have to be removed,
Representation is
sir.
pending.
Defects will be removed. It's a list after removal of defects.
Obliged.
Weekly list item number 11. Weekly list for orders item number 11.
Pass over.
Weekly list item number 12.
Sir. Sir, this case is what I filed a PIL. This is basically a constitutional matter. Article
There are
13.
some defects, Mr. Goswami.
Yes, sir. Yes, sir.
So you'll have to remove those defects.
Yes, sir.
List after removal of defects. All right.
Yes, sir. I'll remove it, sir. I've also, sir, this is basically a matter of 13.2 versus 368.3.
Anyway, you remove the defects, we'll examine it.
Sure, sir.
Weekly list item number 13.
Lord, may I plead, my lord? Lord, in this case, petitioner challenges the virus of notifications of 2016 and 2020 rules, my lord. Only in order to get appointment under the 1990 rules, under which rule his father died on, my lord, in 2012, my lord. Lord, the honorable appellate court decision is there, my lord.
When are those matters coming up?
Pardon?
This is the same rehabilitation assistance.
Yes, ma'am.
When are those matters coming up? There's a huge
Yes.
batch you have filed.
7th July.
Notice, we all accept notice, registered on 7th July. All right.
Already copy served, my lord.
All right.
Weekly list item 14.
This is a similar type of case of Puri Jagannath, Sri Jagannath temple.
Let's pass it over. Somebody stop here.
Or your lordship may fix it to that date when that case will be.
No, if they come, we'll fix
okay.
it.
Weekly list item number 15.
Pass over.
Weekly list item number 16.
Passed over.
Weekly list item number 17.
Item number 17, my lord, I am appearing through VC, my lord, if I may please.
Yes.
My lord, in this matter, we have
Defects not removed.
My lord, that's another thing. And my lord, the intervention has already been filed. We'll be filing the objection, my lord. My learned senior have filed the intervention, my lord, in item number 17.
We as the project proponent, we have filed an intervention application because they have not made us parties. So they may remove the defect, and if any objection they want to file, they may file it.
List after removal of defects. All right.
Obliged. Much
Weekly list item number 18.
18, my lords.
Defect not removed, sir. List after removal of defect. All right.
This is actually that RERA matter, your lordship has fixed it to 26th. On that date also it can.
That is only about the apartments and
Yes.
duplexes. It is regarding the subdivision of lands. They are not following
That is
the
related to apartments and it is relating to
subdivision
land.
of plots.
Plots.
Anyway, it can be listed after removal of
defects. Yes.
Weekly list for admission item number 19. Item 19.
Number 20.
Lord, pursuant to Lordship's last order, my Lord, the encroachment has been removed, my Lord.
It's been removed?
Yes.
All right. Where the compliance evidence is there?
My Lord, yes, I have the hard copy. I think the office has pointed out it has been e-filed, my Lord.
Right. You say the compliance affidavit has been produced. It confirms that the encroachment on the remaining area of 0.6 AC 0.660 decimal has also been removed. That view of the matter, no further directions are called for in the present petition. Still post off.
Weekly list for admission, item number 20.
20, my lord. In this case, today I received two affidavits. One filed by WATCO and another by BMC.
Oh.
And the other copies I have not received.
BMC, my lord.
To be filed by.
I'm filing, just please check.
So affidavit is handing.
May I clarify one thing in this?
Yes, Mr. Naik.
My lord. Actually, two opposite parties were implemented. Opposite party number 7 is JICA. JICA and Orissa Water Supply and Sewerage Board have been implemented separately. OWSSB has been represented, but JICA has not been. So I have today filed Vakalam for JICA.
Okay.
And on behalf of JICA, I have filed an affidavit today itself.
All right. Mr. Naik appears on behalf of JICA, bracket opposite party number 7, and has also tendered an affidavit in court today. Copy of which has been handed over to Mr.
No, copy has not been handed over.
My lord also implemented the East Coast Railway as a OP number 8 on last occasion.
I'm handing over copy, right?
I am not received the copy of the same. Let them survey copy.
Storage board.
My lord.
My Lord, on last date, my Lord, Odisha Water Supply Storage Board was implemented and I had entered appearance, my Lord. Lord, your Lordship grant us one week time to file.
All right. Mr. Das appearing on behalf of the Orissa Water Supply Sewerage Board seeks and is granted 1 week's time to file an affidavit. Mr. Mohanty and Senior Counsel has handed over an affidavit of the BMC.
Yes, sir.
Copies of the affidavits filed today be served on
Already, sir.
learned amicus curiae.
Already, sir.
Have been served on
BMC has handed over.
OP8 is railway. OP8 is railway.
Hello, let our power come in the list because last time the Bhagat has been filed, but it is not reflected.
No, Mr. Padi, what do you want?
My lord, the East Coast Railway implemented OP number 8. Copy didn't receive and no paper has been received by either of the parties.
The party says that he has not received any copy of the petition.
Only one counter I have received, nothing.
All right, Mr. Raut will arrange to serve a copy of the petition on
My lord,
the party appearing for the East Coast Rail.
my lord, so far as this BMC report is concerned, a direction may be issued to give a copy to me.
Just now.
And your lordship may write that along with me, Mr. Ishwar Mohanty is the new ASC.
All right.
Today he has joined, he will be appearing.
All right. All right.
Mr. Ishwar Mohanty, additional standing counsel.
All right. All right. Mr. Ishwar Mohanty's name be included.
Additional standing counsel.
All right. All right.
Weekly list, item number 21.
Let sub item number 2.
This case, my lord,
Number 21.
I'm in virtual matter.
All right.
Recently, in past matter, my lord. Recently, I have received the counter, my lord. 1 week time required for filing the rejoinder.
So, my lord,
Actually, in item number 1.
I have a submission, my lord. This 7090 is concerning to the user fee, my lord. Lordship have observed clearly in the last order on 10th of March 2022 that this is a user's fee matter. And the second matter, my lord, is concerning to the holding tax. So therefore,
so far the second matter is concerned, that is a single judgment.
So therefore, the 7090 matter, my lord, where my learned friend is taking adjournment for filing rejoinder, that is to come along with 11885 of 2016. My lord, have already segregated user item.
Okay.
WPC
So
1190,
7090, Mr. Raut seeks and is granted time to file rejoinder for the next date. List this petition along with
11885 11885 of 2016.
11885 2016. Any date given there?
No, my lord, the date was given sometimes in the month of January. It has not listed. It is to come.
All right, on 5th September. On 5th September.
9929, my lord, the next matter. I am for the petitioner. That if your lordship remembers, this is covered by your lordship's earlier judgment in Kalyani Maternity Hospital.
I know, but Mr. Acharya, it is pointed out that this can go before the single judge.
No, my lord, it is a division. Your lordship's judgment, my lord. It's this particular because the virus was not a challenge.
You had moved in the single judge matter. This is arising out of Orissa Municipal Corporation Act.
No, kindly don't
we'll be
make the
losing another
confusion.
forum.
There is already a division in judgment of this honorable
No,
court.
so that will be applied for the single judge.
No, we have filed the SLP also, that is there.
So SLP was
also to 47.
Mr. Mohanty, kindly permit me. I am for the petition. Lord, your lordship, this particular matter was heard by your lordship earlier, 9929 of 2020, and a submission was made by the Law and Council for the Corporation BMC that they have
coming up on 4th July.
That's correct. That stands adjourned to 4th July, and they
All
told
right,
I
we'll
think
consider on that date.
January they filed the SLP.
9929, you say list on 4th July, the date already fixed. All right.
And it was segregated also from other
Anyway,
interim order
now
to continue.
now it will stand segregated. All right.
Let's interim order to continue.
Interim orders to continue. All right.
Sir, I need to excuse me, sir. Item number 19 I just missed because out of line. Item number 19, I missed the list because I was disconnected from the.
What have we said in that? It's been complied with, sir. That remaining encroachment has been removed.
Obliged.
Weekly list item 22.
May it please your lordship. The client was not in contact. So
All right.
please.
Counsel of the petitioner states that she has no instructions. Dismissal numbers. All right.
Weekly list for hearing item 23.
My lord, item 23, Mr. Das, senior advocate, is appearing in this case and he is out of town. Maybe taken up next week. Any day, my lord.
Sir, these matters are never proceeding. What is all this? Every time criminal appeals, only adjournment is being sought.
My lord, in this,
This happened before vacation. We kept it today. He says a last opportunity list next Monday. Acha, keep it for next Thursday. As a last option list on Thursday. Next Thursday.
Next afterwards.
Yes.
Weekly list item 24.
Lord, I have received the paper book, but not well prepared, so I prefer and sought adjournment. So keep it on next Monday or any other period.
Next Thursday. This again, say the last opportunity list next Thursday.
Weekly list item 25.
My lords, this is a matter where on the last occasion I had said that there are 3 more matters. Now I find that those 3 matters have been disposed of. So, and one is for defect removal, not removal, as your lordship makes it, that they will not be admitted. The 176 of 2001.
Correct.
That leaves only one to be argued before. Now, I have given a note to your lordship so far as non-applicability of the Rajasthan judgment on which your lordship has relied. The tribunal has relied. The Rajasthan judgment has itself been modified by a subsequent judgment where Justice Jeevan Reddy was a party. And that judgment was by Justice Hansaria. They have said that that judgment did not indicate the object of the law, which they have added in para 13 of the repetition of the judgment. So on that basis, they indicate that Rajasthan may not be a correct judge.
Where is your note, sir?
I've already given it to yours and my friend is handing over to you. He filed it and
he's bringing it.
Unfortunately, I gave a very larger note which I had given to your lordship when I was arguing a matter long back.
You got it, Mr.
Standing-
Padi?
Just got one.
It's got it.
48-page note, Sumati.
And this is a solitary matter which comes up here in Orissa. Unfortunately, Robinson barley is not taxed in other places beyond 4%.
Oh, I see.
Anxiety, but by their conduct, they have lost 4 cases. So your lordship may follow them and dismiss my case. So you try you somewhere else. But if your lordship is going to give me a hearing, I have given a note. Let the London Standing Council give a reply to it or go through it so that I can shorten it.
When shall we have it?
2
weeks convenient to us.
All right. A detailed note has been submitted by Mr. Mohantil and senior counsel for the petitioner in these petitions. Mr. Padi states that he will examine it and make his submissions and be ready for the arguments in the next date.
Lordship putting it to
Monday.
26th.
4th July.
4th July.
Right.
There is a development of this proposition by the Supreme Court, and they have indicated what will be the owners of the state in making the notification and the authorities, which should not come to the court to be decided.
All right. Okay.
Great.
Possible. Weekly list passed over matter, item number 3.
None appears despite a possible. This was not prosecution.
Weekly list passed over matter, item number 5.
None appears despite a possible.
Weekly list passed over matter, item number 11.
None appears despite a possible.
Weekly list passed over matter, item number 14.
Item 14, Your Lordship, similar matters has been posted to 27th, Your Lordship.
27th?
26th.
26th.
6th. I'm sorry, 22nd.
Day after.
Day after.
Day after. List day after.
Obliged.
So you know the consequences.
Lordship.
To the Honorable Supreme Court should have no
costs awarded by the Supreme Court. In fact, one of the questions I'm going to ask them is, have they paid those costs?
They are collecting the cost.
I see.
On behalf of Mr. Deepak Jain,
I know. I'm just saying, be conscious of that.
Lordship.
22nd. What? That's it.
Another reason. Weekly list item number 15.
None appears despite.
Your Lordship may indicate my name. No copy has been served on me.
Anyway, the person, party in person also. Same problem.
Weekly list item number 16.
None appears despite a possible. This was not possible.
Oh.